Hello everyone, welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Mr. Veril Vora with us. Veril is a managing partner of VPV Legal and Associates. He's a graduate in civil engineering and ran a construction company for over a decade before obtaining his law degree from the University of Mumbai. He did his master's from UBI Belgium and is enrolled on the Rolls of Solicitors in England and Wales. He has masters in corporate and financial law from the prestigious Jindal Global Law School. He has expertise in the real estate, construction, and infrastructure sector. So, hello, Mr. Bora. Thank you for joining us.
Thank you for the kind introduction, Nikhil. Very
This
good
is
evening
all
to
ours.
you.
This is all ours. So, Mr. Bora, please tell us about a complex issue that you worked on and describe the complexity and also tell us how you approached it.
Nikhil, as lawyer, I deal with complexities on a daily basis. But what stands out is pertinent debate that the world is presently struggling with, that is sustainability and development, or in short, what you call is a sustainable development. I was closely involved in a case in a public interest litigation filed by an NGO, which had challenged the Bombay Municipal Corporation's lethargy for not providing proper dumping grounds in the city of Mumbai. Now, this litigation was going on since quite some time, and the Bombay High Court came down very heavily. It passed an injunction order stopping all construction in the city of Mumbai. Now, you imagine how hardline stand the Bombay High Court had taken. No new construction. So I was representing the Association of the Real Estate Developers. We had to go to the Supreme Court and we had to convince the court that the new constructions what are coming up are themselves such that they can handle their solid waste disposal systems. They have a proper mechanism for disposing of their solid waste. And we also gave them the means, ways and means how this issue for disposing the solid waste can be addressed. So the Supreme Court ultimately granted the liberty to allow construction with a condition that it has to be a sustainable development and it should not increase the burden on the municipal corporation for disposing the solid waste. So this was something close to heart, and I felt like it was something for the need of the hour. What you can say, that the development should go hand in hand, protecting the environment, and as a corollary, even the environmentalists should not be such that they look forward for completely stalling the development, because both have to progress. We have to take care of the environment as well as we have to take care that there is development.
All right, great. So now let's talk something about the pandemic, as we are still into the pandemic.
Correct.
So the pandemic saw some courts begin moving towards more remote proceedings and availability. Is this sustainable and a possible way to increase access to justice, in your opinion?
I think the pandemic has taught us many things, and many things have happened for the good. Like you must be aware that courts were functioning virtually. Still, many of the tribunals are functioning virtually, like the company law tribunals or the RERA tribunals. They are still working virtually. The Bombay High Court, as well as the other high courts in other states, have started physical hearings, as well as the Supreme Court. But there is a hybrid system which is allowing people to attend their court proceedings virtually. Now, there is a lacuna. People say that internet has not penetrated deep inside the rural areas. I do not have the statistics to confirm whether it has penetrated or not. But I certainly see that this should be the future going down the line, because, for a person from Kanyakumari or a person coming right from Aizawl in Mizoram, if he has to attend a court hearing in Delhi, I definitely feel that if internet is made accessible to everybody in the every nook and corner of the country, this would go a long way in getting the justice system, more pocket friendly.
All right. And now, Mr. Vora, how would you rate the current legal system drive towards encouraging access to justice? Is there a tangible movement in closing the justice gap?
See, the biggest problem with the justice system presently is the backlog, which is clogging all the dockets of all the courts and the tribunals of this country. Now, anywhere, any legal proceedings you file, it takes a minimum of 10 to 15 years. So the proceeding is decided if you get an interim or an ad interim relief. The interim or ad interim relief going one way or the other, it decides the entire dispute between the parties. So I have seen in my career entirely that what is most important is to either defend your client from getting an interim or an ad interim order against him, or to get an interim or an ad interim order for your client. This sees the end of the litigation. Now, this is changing, definitely. Things are improving with the advent of the new tribunals coming in, the appointment of new judges and all those things. But still, it's a long way to go, and the concepts of taking adjournments at the drop of a hat, and taking adjournments on the grounds that senior counsels are not there. So all those things need to be looked into, and I think the future with the virtual courts and increasing the number of court hours, because if we have virtual court proceedings, I don't see why the courts can also function 24 hours a day. And certain lawyers who are above board can also be made to compulsorily decide certain disputes which are lagging behind, maybe for, say, a particular number of years. And they have to pro bono as an assistance to the court if they are made to decide certain disputes which are long pending. I think that will go a long way in, bringing the people's, the confidence in the judicial system. Otherwise, if any action is not taken now, it would be not in the correct direction.
All right. So now you talked about we are moving more hybrid. So in the era of legal technology, what are the most commonly used tools for you?
For us specifically, what we use as a firm or as individual lawyers now, or everybody, is the easiest answer would be that we were required to refer to so many case laws. Now gone are those days where we used to sit in the libraries for hours looking for a judgment on a particular subject, looking for digest of each and every year and try to find from the respective journals what the cases are. Now everything is available on the internet. So this is the start of it. Many bigger law firms have many other litigation management techniques, or AI is being used to check whether we have any conflicts or something like that. But still, there's a long way to go. Like, in foreign countries, I have heard that they use AIs for, ironing out minor issues which comes up in any litigation. So that should be the future. Like certain points need to be framed for deciding any of the disputes, and that is the way forward, I believe. AI will go a long way in resolving disputes.
All right. So now let us go to a specific sector now. So
Yeah.
do you feel that the recent developments in the real estate law in India, particularly with RERA, are fit for purpose? And are the flat owners now on a more level footing with the developers? How has the pendulum swung?
No, I was always of the opinion that, enforcing of a legislation is more better than making a new legislation. Even today, RERA requires like the developer has to keep deposited 70% of the amounts what he collects in the particular account and to use those funds only for the project concern. Still, we find that projects are delayed. The RERA authorities are, penalizing these developers. Now, there is a mechanism of an appeal. That appeal takes another year or two because in the pandemic, we have seen quite many delays even in the disposal mechanisms of the RERA tribunals as well as the RERA appellate tribunals. Then there is a provision of a second appeal. Now, that second appeal goes to the High Court. Now, High Courts, I have seen that within a year, those kind of appeals are disposed. But what happens is, this is an additional forum where the flat purchasers can definitely get their grievances resolved. What happens is, even after an order of RERA, where do these flat purchasers go? So, in a recent judgment of the Bombay High Court, you must have read it in the newspapers. The RERA authority had ordered the refund of the monies of what the flat purchaser had paid to the developer, as the developer was unable to, deliver the flat. And in the execution, the mechanism is that the district collector has to get the monies recovered from the defaulting promoter as an arrears of land revenue. Now, the matter somehow went to Bombay High Court, and what Bombay High Court did is, yes, it seized the assets of the promoter, but it failed short to take any action against the district collector because it was he who was required to enforce the order of RERA. Now is the time that the authorities concerned are also to be dealt with sternly, because if they fail in taking action, a timely action, they have to be answerable. So my only point in this is, instead of making new laws, you have to see that the existing laws are properly enforced. That is what is required. Otherwise, even if with RERA, if the authorities don't take timely action, even this would become a tool in the hands of the developer, and there will be ways how to, divert yourself and find a loophole and go on with what was happening all the years. So the point is that there has to be a proper enforcement mechanism rather than making new laws. This is my personal opinion.
That was beautifully explained, Mr. Vora.
Thank you.
So now we'll move to the next question now. So the present government has introduced a slew of legal changes on the commercial side with the IBC. So my question to you is NCLT becoming another debt recovery tribunal?
Absolutely. Absolutely. See the roster of any of the NCLT benches. In Bombay, we have 5 benches of NCLT. Half of any day's board would be by operational creditors seeking to take money from any of the debtors, the corporate entities. And ultimately what happens is, half of these matters get settled. There may be a 10 to 20% matters which are of financial creditors where the companies are in genuine difficulties. And remaining something 20% or so must be because of the internal management of the company, some schemes of arrangement and all those things. So the point what I'm trying to make is that this has become a tool in the hands of those persons seeking to recover money from certain corporate entities. And instead of going for a regular money recovery proceedings, they think it wise enough to file a petition before the NCLT and try to pressurize the corporate entity. Now, in a way, it is a good thing that, these corporate debtors who were otherwise too thick-skinned to listen to any small guy seeking to recover money. But in the end of it, like that, the IBC was not meant to protect such small people or such operational creditors who cannot recover money from the corporate entities. The purpose of IBC is completely different. So it is being like, sometimes even the IBC is misused for recovering some monies where there is a dispute, and the corporate entity has failed to initiate any action in regards to the dispute. I know a matter where for recovery of a 2 lakh rupees, one lawyer who had to recover her fees, she filed a complaint against the company before the NCLT under the IBC. Now, after the amendment, at least 2 lakh matters don't go to the NCLT. But it was the time when even any matter above 1 lakh was going to NCLT. So for recovery of such small amounts, and I was representing the corporate person. So they really were not very happy with the services provided by the advocate, and they wanted to withhold some money. They wanted to negotiate and settle with her. But because of the IBC, they were required to pay the entire thing. So this is, a sort of a misuse what is happening with the IBC. It has pros also, but there are cons as well.
All right. So thank you so much for sharing such great insights with us. So now we also look forward to having a chat with you again in the future on some other trending topics in the international legal space. So for our viewers, if you like this chat with Mr. Vora, please like and share this video as much as you can, and also subscribe to ClickAway Creators YouTube channel to appreciate what we do. And you have more coming from the legal space. So this is Nikhil for LexTalk World signing off.